Did you know with some new construction contracts, if you're mad at the sales consultant and you post about it on Facebook, you're in default and you can lose your deposit. Yeah, the Normandy sales contract has a serious gag order on social media. In fact, they actually consider doing this to place you, the buyer, in default, which means they can keep your deposit. You can find it in their extra lengthy paragraph on buyer default. Here's how they phrase it. Purchaser publicly disparage or defames seller, including on social media or the internet. And okay, here's what happens when you're found in default. If purchaser defaults in the performance of any obligations under this contract shall terminate, and seller shall be entitled to retain the earnest money deposit and any other payments, including option money, as liquidated damages. Okay, so it's not that complicated to not post anything bad about a builder on Facebook, but you'd sure want to know that before you lost your deposit and had your entire contract terminated, right? Well, that's not the only thing you should keep an eye out for in new construction contracts before signing. Check this one out. Toll Brothers actually has a clause in their contract that, if signed, forces you to liquidate your assets if you don't get qualified for a loan. Basically they're saying they're gonna force you to pay for the home in any way possible if you can't get the loan you were planning on. I know that sounds crazy, but the contract reads like this. Buyers shall commit to use the proceeds from the sale or other liquidation of some or all of buyer's assets if and to the extent necessary to reduce the loan amount for buyer to obtain loan approval. And just to be sure you didn't miss it the first time, a little later in the same paragraph it reads, buyer agrees to be responsible for and bear the risk of meeting all terms and conditions of the commitment, if any, including the sale of other real estate presently owned by buyer. Notice it doesn't specify the home you're selling in order to move. It just says other real estate. So let's just say you apply for an $800,000 loan and you're only approved for $600,000, right? You know that rental you had paid off for years? You agreed to sell it in order to close. Unfortunately, Toll Brothers isn't finished with their contract terms yet. Here's another one. The seller can take their time, but you can't. The contract states that while the seller, Toll Brother, has up to 30 days to sign the contract before it's technically an executed contract, you aren't allowed to withdraw your offer within that time frame. This is how the contract reads about the seller's timeline. This agreement will not be binding upon seller unless executed by an officer of seller within 30 days of buyer's execution of this agreement. And here's what it reads about the buyer's timeline. This agreement shall constitute an irrevocable offer by buyer for this 30-day period. So essentially the seller has up to 30 days to sign the contract, and during that time you must allow them that full period. Now if you decide you actually want to back out during those 30 days for any reason, unfortunately, according to this contract, you can't. That being said, even though you've signed the contract, it isn't final, right, or executed until both parties have signed. So no matter what assurances you receive from the sales consultant, nothing is officially agreed upon until the higher authorities have also signed off on it. So the seller can back out during or after those 30 days, but you can't. I want you to consider all of the implications there are for you here as the buyer. See, when you place the offer, they're going to require that you also pay your deposit. So now you've paid your deposit, you can't back out, and you have to wait up to 30 days not knowing whether or not they'll even accept. Here's what the contract says. Seller may deposit into any one or more of its banking accounts any such sums paid on account of the purchase price and extras during said 30-day period. Oh, and I love this part. Any such deposit of funds shall not constitute seller's approval of this agreement. So basically, Toll Brothers can take your money and put it into any one of their accounts, but that doesn't mean they'll actually sign the contract. But you still have to wait 30 days to see if they will, because your offer is irrevocable. To sum up this particular clause, I hope you've got plenty of time to wait, because you'll be out a potential $30,000 during that time. And even if you had the funds, you probably wouldn't want to place any offers on other homes, because what if Toll Brothers does accept your offer and execute the contract? You can't back out. So this is definitely another example of a clause you could consider predatory. mandatory. It's clearly written to benefit the builder. With a pre-owned home, if the seller doesn't sign, you can just withdraw your offer. All right, no such luxury with Toll Brothers. Okay, let's talk about the convenience clause for a minute. Normandy's contract is a great example of the convenience clause. At the tail end of their paragraph on buyer default, this is what they say. Upon written notice to purchaser, seller may terminate this contract for any or no reason at all for seller's own convenience. And upon such termination for convenience, all funds paid by purchaser to seller shall be promptly returned, after which the parties are fully released from the contract and release each other from any and all obligations and or liabilities whatsoever. So basically, the convenience clause is exactly what it sounds like. The builder can terminate the contract and keep your deposit at their own convenience for no reason at all. Bloomfield Homes spells it out in terms of if there is a dispute, okay? This is what their contract reads. In the event that a disagreement or dispute arises between seller and purchaser before closing, seller may terminate this contract upon 5 days' notice and will return all deposits paid by purchaser, including funds designated as non-refundable, plus payment of an additional $1,000. So at least Bloomfield recognizes that they are causing you damages and offer a full refund plus $1,000. Now, unfortunately, it's not like you can get back the time you lost. Grand Homes is pretty similar. If for any reason the buyer and seller should not be able to resolve a dispute, they will terminate, return your deposit, and offer you $250. Here's how the contract reads. Seller shall have the right by written notice to purchaser to terminate this agreement, whereupon the deposit made by purchaser shall be immediately returned to purchaser together with the additional sum of $250 as consideration for seller's right to terminate this agreement. Perry Homes also allows themselves the right to terminate in the event of an unresolved dispute, saying, if seller in its sole discretion determines that any dispute, force majeure, misunderstanding, or failure of communication exists between purchaser and seller on or before closing, an impasse, and such impasse has not been resolved completely to seller's satisfaction on or before the closing date, seller shall have the right upon notice to purchaser to terminate this contract. David Weekley follows suit, saying, in the event of a dispute between seller and buyer, seller reserves the option to terminate this agreement upon written notice to buyer and return all deposits paid by buyer plus pay buyer liquidated damages in the amount of $350, an amount which the parties agree to be a reasonable and foreseeable estimate of any actual and consequential damages incurred by buyer incident to the termination of this agreement. So yeah, numerous builders in Dallas have either an unlimited convenience clause, like, for any reason at all, or they'll have one based on if there's a dispute. The escalation clause is something we need to talk about too. This one is particularly egregious, but thank goodness it is pretty rare. The one we've seen is in the Normandy Homes contract, okay? Here's how it's phrased. In the event that there is a price increase in any construction materials, whether for a single material or an aggregate of materials in excess of 10% from the price of similar materials purchased by seller in approximately the same time frame, the excess charges may be passed through to purchaser. So to sum it up, if the price of materials for your new home goes up more than 10%, your purchase price could go up too. So you probably thought, that the purchase price was locked in, right? Well, not with Normandy. Now, what about if you can't close on time? Like, what kind of consequences can you expect with different builders? Well, here's what MI Homes requires. Written notice of the proposed new closing date and payment to MI of a non-refundable closing extension fee of $150 per day for each day the closing is extended. So, hope you heard that right. It's a $150 a day extension fee for every late day. Okay, but listen to this because it continues. Unless, due to the extension, the new closing date will occur in the next calendar month following the closing date, in which case the extension fee shall be $2,000, regardless of how many days the closing is extended into the next calendar month. You better hope your closing date doesn't happen to fall on the 31st of the month, because if you're late even one day, it's not $150 you're looking at being charged now. Okay, it's a full $2,000 to extend the closing. Taylor Morrison's contract says this: if closing does not occur on the date specified in the closing notice due to buyer's default, seller will be harmed. Seller may agree to extend closing on the condition that buyer pay seller 0.1% of the total purchase price per day, not to exceed $1,000 per day. Oh, and you should also be aware that the daily fee is payable immediately, not at closing. If seller approves an extension, buyer shall pay to seller the applicable extension fee upon seller's approval of the extended closing date. So even if you end up not being able to close after all, you've already given them a big extension fee. Bloomfield keeps it simple at $100 per day. All right, here's how it reads. If the purchaser fails to timely close as provided herein, the parties agree that the contract price of the property will increase by $100 per day starting on the 5th day after substantial completion. So at least these fees can be paid at closing. Normandy Homes charges $250 per day with late closing, saying if purchaser fails to close on the closing date, in addition to and without precluding any other remedies, purchaser shall pay seller $250 for each day from the closing date until purchaser closes on the property. So at least they keep it simple. Now, K. Hovnanian tells you exactly what they'll do, but I've got to say it is a pretty steep charge. All right, here's what the contract says about late closing. If purchaser asks to delay the closing date for any reason, including due to delays caused by purchaser's lender, and seller agrees to same, then purchaser agrees to pay seller an extension fee equal to $500 times the number of calendar days from the scheduled closing date until the extended closing date, and purchaser will forfeit any incentives applied by seller. If you didn't quite catch all of that, it's $500 per day, plus you lose all of the incentives you agreed upon when you went under contract. I mean, think about what incentives are. Typically, it's like $10,000 towards your closing costs. The K-Hov contract reads that you could lose all of that if you don't close on time. Property tax finality is another thing you should really educate yourself on before signing. It may seem simple, right? As long as they prorate, it's fine, right? But that's not really the case. You see, the taxes charged for an unfinished piece of land are going to be quite a bit different from the taxes charged for a newly completed luxury home. Now, several builder contracts read that property taxes are final at closing, while others allow them to be adjusted afterwards. Here are several that do not allow that luxury, starting with Toll Brothers. Their contract reads, real estate taxes, community association assessments, and all other charges that are customarily apportioned shall be apportioned to the date of closing. Bloomfield is another one that says proration is final. It reads, taxes will be prorated as of the date of closing of the contract. Perry Homes states basically the same thing. They say taxes, insurance, and other assessments against the property shall be prorated as of the closing. Grand Homes is not quite as clear on the finality factor. Here's what the contract reads. In this regard, real property taxes shall be prorated to the date of closing based on the actual amount of taxes due. Centex makes their policy very clear. Here's what it says. All real estate taxes will be prorated as of the closing date. The proration of real estate taxes and assessments will be based on the most recent tax bill issued prior to closing. All prorations will be final and not subject to adjustment after closing. Now, there are a couple of buyers who allow for property tax adjustments afterwards. Take a look at MI Homes property tax policy. Purchasers shall be responsible for purchaser's share of taxes for the property attributable to the number of days during the year that purchaser owns the property. But if the tax bill is not yet available at the time of closing, then the proration shall be based on the prior year's tax bill or MI's estimate of the taxes or assessments. If the taxes or assessments are estimated, either party may request a re-proration based on the actual tax figures before March 31st of the year following closing. Taylor Morrison also does us a real solid on this one. Their policy here is unusually generous. Okay, so listen up, because the clause starts out the same, as all the new build contracts, right? As most of what we've seen, but you'll see that that actually really helps you out as the buyer. The contract reads, all real estate taxes and assessments for the property shall be prorated between seller and buyer as of closing for the year in which closing is held on the basis of the tax statements for such year provided. But hang on, okay, because here's where Taylor Morrison comes through. The contract continues. If such tax statements are not available as of closing, the tax proration between seller and buyer shall be estimated based upon the most recent tax bill and subsequently readjusted upon receipt of the tax bill for the year in which closing occurs. Seller and buyer agree to adjust the proration of taxes and, if necessary, to refund or pay such applicable amounts on or before January 31 of the year following closing. Now, you know who else does us a solid? Normandy. They're actually pretty generous here too. Here's how the contract reads. If the amount credited at closing is based upon an estimate and the actual tax bill received after closing varies from the estimate in that purchaser is owed more than the credit received, purchaser shall have until March 31 of the year immediately following the year of closing to send written notice to seller seeking reimbursement for the difference between what was paid by seller and what was actually owed by seller. Now, you have to know something. Knowing all of these clauses is seriously important when you're deciding on a home builder, but it really is just the tip of the iceberg. I mean, there are a lot of myths, a lot of lies out there. I talk all about that in this video, which you may want to watch next. In the meantime, Wendy out.